Clark Road Family Dividend Housing versus, is it Deschanay Baker?
Good morning, Your Honor. We do have two witnesses. Would you like them to remain there or
Pardon?
where would you like my witnesses to come?
They can wait where they are.
Over there? Perfect.
What are we doing?
Okay. Your Honor, we've already,
I'm sorry, where am I supposed to go?
right here.
Right here.
We're a little crowded.
All right. State your name.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Your name?
Deschanay Baker.
All right. What are we doing?
Yes, Ms. Baker has already provided possession. So today was just an issue of money damages that were requested.
All right. And you're unable to agree on that figure, is that?
No, sir.
Correct. We do not have an agreement, Your Honor.
Not have an agreement.
Correct.
How far apart are the parties?
I haven't spoke with anyone from the property since I've turned my keys in, so I haven't been able to come up with an agreement from anyone.
Your Honor, if I
Go
may,
ahead.
the defendant has indicated that she has had habitability issues. It's my client's position that there was no habitability issues, and she is requesting damages in the amount of hotel bills that we did not receive, as well as, again, indicating a habitability issue. So we are very far off.
Your Honor,
Would you like us to speak in the hall momentarily, Your Honor?
I probably would, but hold on. What were you going to say?
Your Honor, I'm not asking for any money in return. I'm just asking for the charges to be dismissed and for no eviction to be on my record.
Okay. I understand that last part. What is the total amount of plaintiff's claim?
Including court costs, it would be $3,055.63.
And ma'am, but the court's understanding you disagree with that because you weren't in the premises?
I disagree with that upon many factors. In the landlord's response to my counterclaim, it includes the statement that on August 6th, I denied entry to maintenance and they could see the fan because of the entryway. That is not true. I have proof that I actually asked management to meet in the leasing office to discuss my concerns, and the manager refused to meet me there. She chose to come to my apartment instead. This shows that I wasn't denying access to them. I was just asking to talk in a proper and safe environment to resolve the issues that I had, not only with just the leak and the mold and my pet dying in regards to everything going on in my apartment.
Majority of your claim, how much of that is rent?
$2,207.
I'm sorry, there was a sneeze.
$2,207 for rent, $90 for the washer and dryer rent. Legal fees was $239.40. Additionally, there were unpaid utilities of $94.23.
Unpaid utilities.
Correct, Your Honor.
Okay.
And we do have the bills from DTE and consumers regarding that. And then, or I'm sorry, I think it's just DTE. And then the damages was the amount of $425. And that does reflect a cleaning fee. There was a secondary repair with the drywall due to tenant caused damage. And give me just a moment. And then there was a bulk fee where they had to remove bulk furniture from the unit after she moved out. And then there was also a replacement of the disposal system due to tenant caused damage.
Yes, upon me moving out, there was nothing wrong with the apartment. With me leaving, the disposal working.
Hold on, man. Were you in a hotel or not?
I was staying at family, friends, and relatives. I'm currently couch surfing. I don't have anywhere to stay.
Well, okay. I mean, during this period in time, were you in the unit?
During this period of time, I was not in the unit. I was staying at a family friend's house.
Had you notified the landlord of that?
Yes, I did.
In writing?
Yes.
You have a copy of the writing?
I submitted a paper in writing stating that I would not be paying rent, that I wasn't staying in the property.
I understand what you're telling me.
Mhm.
Do you have a copy of what you gave to the landlord?
Yes.
All right. Have you shown the landlord that?
Yes, Your Honor. The defendant also refused entry for repairs during that time without her being present. And so our argument is that she failed to mitigate the damages. Additionally, repair was made that same evening to the leak in the ceiling that was caused by the HVAC system above her unit. So it had leaked through. She called in sometime after hours by 10:30, 11 o'clock that evening. We have maintenance here on site to provide testimony that they provided immediate repairs, including fans. Within a week, they had a professional carpet company out there that provided additional remediation, including repair or cleaning the couch and the rug. And the repair itself was completed by the 19th.
Your Honor.
And this occurred on the 5th.
Your Honor, that's not true. On the date I was at work that they came to repair the apartment, maintenance entered my home.
Ma'am, let me ask you this. Did you let them into the unit
Yes.
to make the repairs?
Yes. The date that she mentioned, I was not home. The maintenance guy called.
Are you disputing that they made the repairs?
No, I'm not disputing that they made the repairs. They did enter my home and make the repairs.
Okay.
On the 19th, after the leak happened on the 6th. They did not reach out and let me know when they were supposed to come. I had got no notification when the repair was supposed to be made. I had went up to the office multiple times.
So, but why would that?
I'm sorry.
Why would that matter?
What's your question? Why would what matter?
You called in a leak. They came and fixed it. We're all in agreement on that.
They did not come. I called in the leak. No one communicated with me. I called in the leak the night that it happened. 2 employees came and he pulled out where the leak had came from because they said that they had not fixed or changed the filters out. The filters were supposed to be changed every 6 months. I had been living there for 9 months and nobody came.
That's fine, but you called in a repair. What you're telling me is that they came out that night, right?
They came out that night and put a blower in my house and just told me to leave it on the ceiling and on my furniture that had been ruined. Yes.
But
the leak was not fixed that exact night.
okay, but they don't necessarily have to fix it. They tended to what your complaint was, right?
Correct.
And then at some point within those next 2 weeks, they fixed it. You would agree, right?
No, it was not within 2 weeks.
I thought the 16, 19.
Your Honor, the drywall took additional time.
The drywall.
The drywall took additional time.
But the leak was fixed.
The leak was remedied. And then once the leak was confirmed, they did wait, I believe, a couple of weeks to confirm that the leak was finally
Was
fixed.
final.
And they had a
The
third
drywall.
party, correct. And they had a third party drywall company come out to provide repairs. At that time, once the repairs were complete, the tenant did, or the defendant did come back home. There was wet paint from the repair and she proceeded to poke a hole back through the ceiling. That is where the charge came from. The property did not charge her for the initial drywall. They charged for the secondary repair because she poked a hole in, alleging that it was moisture from the leak that had not been an issue for several weeks.
Did you do that?
Maintenance had previously told me that if a
Okay, hold on. Now, you need to answer my question. Did you put a hole back in the drywall?
No, I did not intentionally put a hole back in the drywall. I allowed the water to flow into a bin instead of on my couch.
After they made the repair?
Yes,
What date was that?
19.
Your Honor, we have a photograph of the hole in the ceiling that indicates it's over the door. There's no couch underneath that photograph.
Your Honor, the hole where the leak had happened, my furniture was there. They had, in their counterclaim, said that I denied them entry and that I damaged their property. I was just trying to get my problems resolved so that I could leave the property voluntarily. I was reaching out to compliance and upper management to discuss.
This rent is for what period?
It is for the period of July, August, and I believe part of September.
I moved out September 17th, right after our first hearing,
And the leak occurred when?
August 6th.
So why wasn't July paid?
July wasn't paid because I discovered black mold in the building.
Your Honor,
In the building?
Yes. Throughout the building, there was black mold.
Was there black mold in your unit?
No, sir. There were immense other problems that I was facing while living there that contributed to me not paying rent.
Tell them you weren't paying rent?
in August, we received, or my client received notification in August after the repair had been partially made and the drywall was pending, indicating she was not.
How long, when did you move in?
I moved in January 24th of
So
2021,
January,
but they,
hold on, January, February, March, April, May, June, you paid rent.
yes, on time every month.
So the black mold came in when?
In July,
All of it?
yes.
It just appeared.
The black mold, it came from an apartment that was also leaking water on the first floor. There was also an apartment leaking
So
water
the
on the
black,
first floor.
hold on, the black mold just started to exist in July?
The black mold did not just start to exist in July. It's when I became aware of the problems that not only I was
So when
facing,
you
but the other
didn't pay
tenants.
July, did you tell them this is why I'm not paying my July rent?
No, Your Honor.
Then you've got a problem, even if true, which I have my doubts. So what I'm going to suggest you do, and then is why don't you take a moment to talk
Yes, Your Honor.
and see if you can resolve it. I will let you know, young man, that I'm seeing certain problems with what you're telling me regarding any type of solution to this in terms of the monetary amount. But we can all have our positions. I'd suggest that you talk with counsel and see if you can work it out. If you can't, then I'll take you back and we're going to work it out.
Okay.
Thank you, Your Honor.
But I don't know that you really want to talk to me today. But I'm always happy to talk to you. Thank you.
Thank you.
Thank you, Your Honor.
Yep. Okay. Go!
Will you hand me my screen box?
Now go. Preach.
Were we ready on Clark Road or? I'm so happy. I don't know what that. Court does recall the case of Clark Road versus Baker.
Good morning, Your Honor. Attorney Samantha Sprague, Pete 1931, appearing on behalf of the plaintiff.
Hi, Your Honor. We weren't able to come to
I
an
need
agreement
your
with
names.
Dejan Baker.
All right. Are we on that?
We weren't able to come up with an agreement. I would like to request that this case proceed to trial. I've been dealing with ongoing issues regarding Huron Vista, including attempts to charge me additional amounts that I don't believe are fair. I also want to note that when I moved in, I was not given a properly signed lease. There were more inconsistencies with rent charges, my move-in date and prorated
Ma'am,
rent.
did you pay the rent?
Huh?
Yeah, I don't know what you mean by a properly signed lease.
When I moved in, I did not have a signed lease. I did not sign a lease.
Okay, but you stayed there, right?
Correct.
You paid rent.
Under the impression I had a signed lease.
That's the only reason you paid rent?
No, Your Honor.
The moment you stayed there and paid rent, you created, the tenancy was created. So I'm not sure why you are bringing up the fact you're saying there wasn't a properly signed lease.
Because I would like to move forward and take this to trial. I don't believe I'm getting my points across.
You don't believe what?
I'm getting all of my points across.
Oh, no, I'm understanding them. But they, quite frankly, I'll be honest with you, I mean, I'll hear the case, had evidence to put on, but I'm not clear what you're really arguing.
What I'm arguing is that I did find the paper that I reached out and submitted in writing about the black mold when I found it in July. I did reach out to the apartment complex. I would like a court-appointed attorney. I don't feel,
That doesn't happen in the civil case, ma'am.
okay.
If you're gonna go to trial, you're gonna have to try it yourself. And my question is, are you prepared to do that? Because you're gonna be bound by all the same rules, the court rules, evidentiary rules that counsel would be bound by.
Yes, Your Honor, I understand.
You're prepared to do that?
Yes, Your Honor.
I don't understand what your defense is to this.
My defense is that since I've lived in this apartment complex, I have not gotten any communication in regards to my problems that I faced living there. I've reached out and talked to more than 5 property managers that's worked there in the past 9 months. All of my problems were not fixed. They were completing work orders that were not actually completed. They were just marking them as complete.
Ma'am, what did they not do?
Anything.
No, that's not an answer.
They did not fix the leak. They did not. I'm sorry.
What do you mean they didn't fix the leak?
Give me 1 second. Landlords are legally required to keep the.
I don't need to be read anything. You have told me that they did not fix the leak. I just went through the whole thing. You agreed they fixed the leak. So what do you mean they didn't fix the leak?
What I mean by they didn't fix the leak, they did not communicate with me as a tenant to give me the communication of when they were going to enter my apartment and how everything was going to get handled. No one communicated back to me in any of the responses when I've reached out to them and let them know the problems that I were facing living there.
Did they fix the leak?
Yes.
So what do you think them, if it's true, which I'm having some doubts that they didn't talk to you at all, what are you claiming that's worth?
I'm claiming that that's worth the $17.90 that they initially brought me to court for.
Because they didn't talk to you?
They didn't communicate and they entered my apartment without permission. They violated my rights. Not only one.
You call, say I have a leak. They at some point, because that's an emergency situation, enter your property. And that's your claim?
They entered my property the same night to fix the leak. And then they tried to enter my property 2 weeks prior to the leak happening to enter my property to fix it with no communication. They came to clean my couch a week after the problem had already happened and my couch was ruined. That's a $2,000 couch that was ruined. The leak was not only in just one part of my apartment, it spread throughout the whole entire apartment. There were cracks in the ceilings that were supposed to be repaired from construction that never showed up.
Entering your unit inconvenient.
It inconvenienced me because I was not only dealing with just
You know
the
what?
leak.
You got your witnesses here today.
I do, Your
I'm going to squeeze you in because this is going
I also have a
to be
witness.
a quick trial.
I also have a witness here.
That's fine. I'll hear from everybody, and then I'm more than happy going to render that. The only issue is that I have criminal cases; those have to take precedence.
Absolutely.
But I'm ready to hear this today. It's not going to take time at all. I'm going to tell you right now because I do not. I'm going to let you know, young lady. I will hear anybody's claim. I do not understand your claims, and the claims don't make much sense to me.
And I will make sure that I will make them make sense.
They don't make sense to me. Young lady, I'm trying to communicate something to you. I've been doing landlord tenant for over 35 years. Your claims don't make sense. But if you want to go ahead and call witnesses, do all the questioning, go through all of that, we'll do it.
Okay.
And then I'll render my decision and you're stuck with it.
Thank you, Your Honor.
Ms. Baker? You had indicated, and I just wanted to advise you, that you had wished not to have a judgment in the case? Okay, I want you to understand that if I hold your trial and I render a decision, you will have a judgment if it's against you. You understand that?
Yes.
You understand also that if you wanted to speak with counsel, there are ways of working it out where there would not be a judgment on your record.
Yes.
Have you talked to counsel about that?
I have not been able to get in contact with anyone from council.
No. The individual here today.
Yes. Sorry.
Did you talk to her about that
Yes.
scenario?
Yes.
Did you guys talk about that scenario?
Conditional dismissal with a payment.
But you're not interested in that.
No.
I'm just saying because you had indicated to me that you did not want a judgment. And you understand that if I render a decision, it's not going to be with the payment plan if it's against you.
I have a question. With that being in mind, would I have time? Would I have time to pay? If it was under against-
Ma'am, the best I can advise you, because I want you to fully think about it, is that you might have time to pay, but any remedies for collection of that, including like garnishment, other things.
I'm fully aware. I still want to proceed.
So you're going to interrupt me again?
Sorry.
I was answering your question, but it seems you want to just proceed it. You can do what you want to do. I don't. Let me do a couple of things. Buck Road, family dividend versus Baker.
Good afternoon, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Okay.
Janae Baker.
I have before me a consent order for conditional dismissal that indicates that the defendant would agree to pay $2,000 on or before 5 p.m. on October 30th, 2025. No personal check, only certified funds. Defendant pays on or before October 30th, 2025. Plaintiff will waive the remaining balance. That's basically the court's full understanding, except to make it clear that if you don't pay that, then plaintiff would be entitled to a judgment of the full amount of the including cost of $3,055.63. You understand that, ma'am?
Yes, ma'am. Yes.
Are there any other questions that you may have regarding this conditional order dismissal?
No, sir.
All right, so you understand everything?
Yes, sir.
All right. Thank you, folks, for resolving it. I will sign off on that, ma'am. You have to advise you, since you are here unrepresented by counsel, you have 3 business days to think about this. If you think that there's some legal reason on your part or some right you didn't assert, you'd have to file a motion with the court within that time frame. You understand that?
Yes, sir.
Doesn't mean that I would grant it. You have that time to think about it, file that motion. You understand that?
Yes, sir.
All right, very good. Ms. Baker, let me say something to you. Sometimes you can come in with the greatest of all intentions, but I think you could have had this resolved a whole lot earlier had you maybe proposed that to counsel and kind of worked it through, realizing what your potential liabilities may have been in this case. Okay? So if nothing else, I hope not only with regard to a satisfactory settlement of this, that you learned something else from this.
Absolutely.
Thank you, Your Honor.
Thank you, folks. Cassidy Jerome versus Cassidy.
Your Honor, Abby Cooper appearing on behalf of the Jeromes. Gail Rosen appearing on behalf of Paul Perez Cassidy.
Joe Lloyd, Your Honor, on behalf of Cassidy's.
Oh, boy. You know, it's like Lloyd, he just shows up in things. I know, everybody. There's a nice group before, and now Lloyd's here. All right. What are we doing on this? And we received, I did not grant it because I was off yesterday, but an ex parte motion to adjourn from Ms. Tope. So I've done nothing with that.
I have not seen an ex parte motion to adjourn from Ms. Tope.
Probably because it's ex parte. But just saying. but she filed, well, I don't even know if she filed it per se. She sent it to my staff, indicated, I think, and correct me if I'm wrong, that she's on a plane, could not even Zoom in. So I don't know what that means. Wasn't going to deal with it yesterday when I heard.
She did send us an email to that effect, Your Honor.
Got it. Okay, that was the substance of the motion. All right, where are we now on this case?
Your Honor, we've spent I think a great deal of effort trying to settle this case on our own. We thus far have not been able to do so successfully. We've made some progress. Seem to be a few little hurdles in the way. I still think it's possible to settle prior to trial. If Your Honor is willing to take this on himself before a trial, it may be a judicious use of resources. But barring that kind of effort on the court's behalf, I think the only thing left to do is set a trial date.
Mr. President?
Your Honor, we agree that we need to have a trial date. I mean, I think that'll give everybody something to shoot at. There's a couple of things we need to do beforehand. We need to clean up the pleadings a bit. I think there was some pleadings that were filed in early versions of this case that aren't in this one. And we'd like, for example, 2 weeks to get our pleadings cleaned up.
You mean in terms of the...
There was a counterclaim in one of the earlier cases. I don't know that there's even an answer in this case.
Well, we had kind of postponed the filing of certain answers because the parties were working diligently to try to resolve them.
If we're going to try the case, we've got to file the answers and stuff.
Well, that's correct, but that is certainly not where we were hoping to head if we didn't have to.
I
So
understand that.
we were trying to, well, I don't know what we were trying to do.
It's complicated. And the other thing that in conjunction with Ms. Toth, what I don't want to do, I've looked at their lease. It's not clear to me at all exactly even who the parties are. It looks to me clear that what she did is cut and pasted an old lease. But we might want a hearing of some sort with the court just to resolve, who the actual landlord is, whether Ms. Toth has any claims or role to play in this. I believe she does not, but I feel much more comfortable with a court order. And so if she's got some claim she wants to argue, bring it now.
Well, that causes some, I won't say problems, but one of the issues is she certainly was holding herself out as I guess the best way to put it is either manager or the landlord.
We believe she's a witness, and
well, there's no doubt about that.
Yeah, no, but if she can prove something, what I don't want to do is I don't want to finish this and then find out it's risen from the ashes. And so,
in terms of what?
Her showing up and saying, no, she has a claim still. So what I would propose to do is we'll file a motion.
Well, and I don't mean to interrupt you, or maybe I do, but her claims, as I understood them, were solely were really the landlord's claims. The landlord, however, may disagree with that.
And Your Honor, if I may refresh your memory, the Jeromes are here because the Jeromes filed a motion with the court indicating that Donna was the landlord, and the court declined that motion and indicated no, the pleadings had been filed on behalf of the Jeromes. The Jeromes were on the landlord side of this action and denied the motion.
Correct. And that, right, and in part, basically, I want to say this, there were things that were happening that I'm not sure were necessarily in the Jerome's best interest. I'll just leave it at that.
Yes.
And involved certainly Miss Ho, and then her claims. She had certain claims, and then the Jerome, I wanted to leave open the possibility, certainly for the Jeromes, that they may have claims in some way as to Ms. Toe. I think I got that. So you're looking to straighten out.
One, to get our answer on record, so if we're trying a case, here's the pleadings, here's the claims.
Correct. I mean, if we're
And then-
I think a lot has to be cleaned up if we're gonna try it.
I think you're right, Your Honor. And the way that I think some of the discussion has been amongst counsel present in this courtroom is that we're looking to bring only landlord-tenant claims in front of this court for a landlord-tenant trial.
Correct.
There is a separate action in the circuit court that Ms. Topaz brought. It's an assault and battery thing that she's done.
Yes, I think she had done that.
And we have
She
a
had.
trial scheduled in that case in May, I think. It's, that's
May of next year.
next year. That
That's
case,
a perfect. No,
that case is proceeding and we will resolve it. But we don't want to duplicate stuff. And so I think if there's a landlord tenant case that involves her, I want to know it now and be done with it. And I don't think there is. But
If
I'd
it
love a court
involves-
order to that.
if it involves her,
Yes. I mean, something where she has a claim against my clients. I do not want that to resurface after we're done, other than what's in the circuit court. And yeah. I don't mean to be,
whether Ms. Tope has claims as against your landlord tenant claims.
yeah.
So the part, currently Ms. Tope is here through Cambridge Holdings LLC. She individually is not a part of these proceedings.
Correct. Does that help you? Or no? Given the look on your face, no.
No, I would like what I don't want to have happen is I don't want landlord tenant cases to surface in the circuit court and her say, well, those weren't addressed in the district court and I still have them. And I don't want her to refile in the district court. I want to be done with Donna. So, and I was hoping we could
But that
motion of some
claim-
sort.
Well, and that may be part of the other issue. As I understand, just on the surface, the assault and battery that she's claiming came as a result, allegedly, of involvement regarding the tenants.
Yes. I mean, is it a claim of her against the tenants? Yes.
Pardon? Right, her claims against the tenants. So I don't know. I mean, I probably have to think that through a little bit more, but I don't know that it could be fully separated out as you'd like it to. Because I think she's gonna make or can make certain claims. However, as to whether or not those claims are proper claims, I can't say for sure. I have my doubts, but
I'm hoping we can present you with a motion that will persuade you. So, but I'd like to be just done with that with Donna as regards to this case. And we can try this case fairly clean.
okay.
And I don't want it to resurface. That's my goal.
Understood. Ms. Rosen, you have been conspicuously quiet. So,
Letting Mr. Lloyd do the talking today.
what?
Letting Mr. Lloyd do the talking today.
Oh, no, don't do that. For my sake, don't. Okay, so where do we want to go from here?
Let's start with a trial date and that we can work against. We'll file our pleadings within by the end of next week at the latest to clean them up. We can circle stuff back and forth. With the permission of the court, we would file a motion and serve Ms. Tope and let her make her claim. I'd like to end up with an order, a final order as regards her in this court on landlord tenant things. And we have to persuade. I understand.
But you understand that she doesn't. There would be an order maybe clarifying what she is in this case, but it doesn't make her go away. In this case.
Hold on.
I don't see that happen.
Okay. So we'll get as close as we can. Then we still have to deal with the circuit court case, and I know that, and I'm not trying to get around that.
So in terms of cleaning up the pleadings, how much time did the parties need to get that done?
End of next week for us, please. That would be,
But then there's going to need to be potentially responses.
yeah.
So maybe why don't we look at, can everybody get everything done, even if the timelines are shortened by the 18th or 17th of November?
Yes.
Well, say the 18th?
Yes.
Isn't that a Saturday?
We're gonna need them. I can clean up my pleadings too, because I do
Okay.
think there's,
Oh, no, it's.
so why don't I go, do you want me to go first?
On,
On cleaning up the pleadings, because I think on the landlord side, there's some cleanup to do as well.
okay. I mean, you know.
Because I don't want you to respond to what's on there currently. I think,
Okay. Good.
What just happened?
I think that the landlord would like an opportunity to clean up the pleadings on the landlord side, so we should probably go first. And then the tenants are responding to the most recent pleadings.
All right. So how fast can you do that?
I can do that the week before the 18th, Your Honor.
The week before the 18th.
So that would
Then
be,
you need time to respond to that.
We
So
do.
what's
And there will be a
next?
counterclaim,
Pardon?
and then we may have a counterclaim, you know,
That's what I thought.
yeah.
okay.
So, it's my next date after the 18th. Okay, so if the landlord has everything in order by the 17th, any responses, counterclaims and the like would then need to be addressed within the next 2 weeks after that,
Okay.
It's December 1st, something like that.
by December 1st. And then what I would do is I'll set another pre-trial final settlement conference December 2nd. Just because we have to make sure everything's in order. To have that. Go ahead, Mr. Lynn.
If we file on December 1st and there's a counterclaim, we won't have an answer to that at that point.
Correct. Oh, I'm well aware of
Okay.
that. I mean, I get it, but if I put it further out, then you're gonna have to answer. What I may end up doing is saying you have to answer the counterclaim by a certain date, a trial date.
Okay.
That kind of makes sense. I'm just trying to get everything back on track
Mhm.
so that we know exactly what we're dealing with, because we didn't. Now, the one wild card in all of this is I'm not sure what Ms. Hope will do with all of this, because some of the claims, I think, from the landlord are going to potentially involve her, or maybe the counterclaims are going to. So I think it's probably better that we have that pretrial, because she's going to, I would imagine, have to respond to some of that. If that makes any sense.
Yeah, I don't think we are planning a counterclaim that would be directly against either Donna or Cambridge as a party. Now, she may be a
Right, but the problem's going to be that the counterclaim, so the initial claim is going to involve certain things. Your counterclaim would then come,
Yes.
but then the response to that counterclaim, I can imagine, at least knowing what I know about the case, may involve some of the actions of Ms. Toe.
Okay.
That's-
We'll deal with it when it arises.
And Joe for filing the motion.
And how I've handled
That you
Ms.
want-
Toe.
Now, so how would you visualize this interacting with the motion we'd like, just to clarify Ms. Tope's status?
Okay, so what I'll do is I'll set a final settlement conference for December 2nd. Any motion you'd like to clarify the rights of the parties, I would need filed with an opportunity for the parties to respond. So you need to file that in time for them to
In time.
respond, and then I can rule on that
So you-
On that same day?
on that same.
You're arguing it on the second.
Yes.
Okay.
Yes.
So the second at 9 a.m. for final settlement conference and to argue any motions.
Yes. And then from there, once everything's cleaned up, then I can give you a clear trial date and see exactly.
Good.
Okay.
That makes sense.
Thank you.
Thank you.
I really want to say you're welcome, but
No. We have a direction now. We know where we're
Yes.
headed. And
all
I-
right.
Thank you.
Thank you.
Thank you, Connor.
Well, no, I did, but it's over here.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're gonna start bringing people in person. We're gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
No, trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.